You now stand charged with another case. You now are charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
The complaining witness, who is the ex-boyfriend, made a report to officers that his ex-girlfriend, the defendant, was sending him multiple text messages threatening to harm and kill him. Specifically, the defendant sent, "And I'm calling GD to fuck your shit up. You said some fuck shit like that, I will kill you. I promise you that." Complainant stated that he was in fear of his life.
Probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with this person whatsoever and not to be in possession of weapons. You picked up a case while you're on bond. Guess what happens now? Guess what happened, man?
Hold on. This is already a major red flag. The judge just pointed out that the defendant picked up a new harassment charge while already out on bond. In the court's eyes, that's one of the fastest ways to lose credibility. What do you think? If someone is accused of threatening an ex while already under court supervision, should the judge get tougher immediately?
What is the one thing I asked you not to do? What have you done? Correct. Your logic is impeccable. So guess what happens? She goes with me. Okay. Alexandra Loyola. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
The complainant and the defendant were dating at the time of the altercation. On September 19th, 2024, officers were dispatched to a disturbance and met with the complaining witness, who stated that both the complainant, both her and the defendant, were intoxicated and got into a verbal argument. And he tried to grab his keys and leave. The complainant tried to grab his keys and leave. Defendant then punched complaining witness multiple times with a closed fist with both hands, causing pain. Officers observed complainant to have red marks, bruising on the back of his left ear towards his neck, and a scratch on his forehead. Officers attempted to detain the defendant. The defendant became combative, kicking the officer on the front and back of his leg, causing pain.
Yeah, I see that she picked up the assault of the peace officer as well. That must be a heck of a video. Ms. Loyola, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using any alcohol or dope, and I don't care what it is, I don't care whatever source it is, you're going to go to jail. You will not get any more PR bonds. Do you understand? Do we know what he wants?
I see that a call was made. It says that he wants no threatening, harassing contact with the defendant.
It's a protective order. Yeah, it looks like a protective order has been issued in this case. I would get to know it. If you do something to violate the protective order, the state can and will file additional charges against you as a violation of a protective order. And that's one of the worst cases you can pick up. You start violating conditions there, I can hold you at no bond. Zero bond.
This is where the case becomes bigger than just one argument between two people. The judge is now talking about protective orders, additional criminal charges, and even the possibility of being held without bond. And when CPS enters the conversation, the stakes skyrocket. At this point, the question isn't just about guilt or innocence. It's about whether these decisions could impact an entire family.
Until this case is over with, and I will do it in a heartbeat to protect every person in my town. Do you understand?
Please, sir. Please we have the case together. So, how would I do for him? Let him have him.
Let me ask you this, though. Has CPS been involved in your life? What's going on with that now?
Did you come to my house? Did you talk to me and then go to his house, talk to him, and really it was his self-defense. He had assaulted me
I'm
before.
not talking about the case. I'm not doing that now. All I'm saying is that now this is your third case that you're working on, right? You've got young kids. What's going to happen if you go to jail for 6 months? Who's going to take care of those kids? What do you think they're going to say? Hey, where's mommy? What are those kids going to say?
I'm
not saying anything about your kids. I'm telling you now, I don't want you to have contact with this person. No contact whatsoever. And it doesn't matter to me. I mean, you're going to have to find an intermediary for the kids, but just no contact and no weapons. And I'm going to tell you now, if you continue to pick up cases, just kiss the kids goodbye. CPS will take them in a heartbeat. And I'm going to tell you now, when CPS gets involved in your life, it gets extremely not only expensive, but time-consuming, arduous, and your life is going to go even more sideways than it is now. So, no alcohol, no drugs, no contact. That's all I'm asking to do now. And don't pick up any new cases. I will tell you that I won't give you any more PR bonds. So all I'm asking you to do is just behave. That's it. What do you do for a living, man?
I'm a subcontractor for HUD.
Sorry?
I'm a subcontractor for HUD.
Okay. And what kind of money do you make a month?
$2,500, maybe less. Right now, students know. So I work for job.
Did you want to apply for an appointed lawyer?
Yes.
Okay. Let's see if I have an application. All right. I have an application on file. Vic, we can appoint a lawyer. So I'm going to have you sign a receipt with Victoria. After that, we'll have you take a seat in your box. You will meet with pretrial for your bond conditions. And after that, we'll have you talk to someone here shortly. You're walking and you're skirting a thin line. Just be careful what you do. Do you understand, man? Okay, please. So, tell me about the test, please.
Judge, Ms. Lewis had a medical marijuana card from Louisiana.
It makes no difference to me.
Your Honor, she does have lupus, so I think that's the reason she was given the prescription for medical marijuana.
In Louisiana, great. But you're not in Louisiana. You're not allowed to use, and I made it a condition of your bond that you're not allowed to use. You're in direct violation of your bond. And no means no. You have a DWI. How do I know that you're not going to smoke marijuana, get another DWI with a marijuana case? Because it's don't matter. It doesn't have to be just alcohol. DWIs could be with marijuana. They can be with PCP. They can be with cocaine. They could be with whatever. It could be NyQuil. If you drink too much NyQuil, what does it do? You get intoxicated and you can pick up a DWI. It could be an Ambien DWI. It doesn't mean just alcohol. That's why we tell you not to use any intoxicating substances. Don't use illegal substances. So what all did she test positive for?
It was just teens.
She wanted to let the court know that she did submit the medical marijuana license and her diagnosis to her pretrial officer, and she just wanted to say she was trying to be upfront about it from the beginning.
We're not allowed to use. How old is this case?
46 days old, I think everyone.
Miss Lewis, in the state of Texas, it is still illegal, and you are not allowed to use it. If you have a problem with that, then go to the legislature and change it. But while I'm here, I have to follow the law. I've sworn to do it. And you are not to use marijuana. I get that you may have a medical condition, but you still can't use. I've ordered it as a condition of your body. You are going to have to find another way to deal with that issue. There are plenty of other ways that you can treat that issue. Marijuana is not one of them. Do you understand? And I'm going to tell you now, I'm going to test you 35 days. I will give you a pass today. But if I find that you use again, and I don't care what your excuse is.
Here's the key legal takeaway from this hearing. The judge isn't debating whether marijuana was prescribed somewhere else. He's focused on compliance with bond conditions. Once a court orders no alcohol, no drugs, no intoxicating substances, violating that order can have serious consequences, regardless of the reason. What do you think about the judge's warning here? Fair enforcement of the rules, or should medical exceptions be considered? Let us know in the comments.
I'm going to lock you up. I don't like to put people in jail, but just some people just don't get it. And I don't know. You have to find another way to medicate, but marijuana is not it. You will get tested 40 days from today. And if you're still positive for marijuana, then I'm going to lock you up. Do you understand? So we will reset this case for 40 days. She'd come back in 40 days. We will test her again. Hopefully she's negative.
Thank you. That's all I have.
You're skirting thin ice, ma'am. There's absolutely no excuse. No alcohol, no marijuana, nothing. Nothing that has THC, CBD, nothing. Okay.
Right this way.